Tafari Morrison against the Dean.
Yes, Mr. Knox.
Good morning, my lords, my lady. There are just a few housekeeping matters arising from yesterday. We have prepared an extra bundle of material to deal with some of the questions raised yesterday, essentially on two topics. First, material about sentencing and sentencing policy in Jamaica, and secondly, material relating to section 13.3K of the Constitution. I hope our bundle was sent over last night. I hope you've received that.
Yes. This is the one that begins with the 1907 Criminal Appeal Act.
That's right, yes. And then I think my learned friend, I understand...
I should say we've only received it this morning, so we haven't really absorbed anything in it.
I'm going to go through it very briefly and explain what it says. First of all, I'll deal with the sentencing material stuff at the beginning, because that arises out of yesterday. I'll leave the section 13.3K matters until I get to that part of my argument. Yep. My learned friend, I understand, has also sent over a bundle this morning, which I think you may not have received. I don't know, because it was sent quite recently. I'm not too sure.
My Lord, I think it was meant to be being downloaded. It did go over in the last few minutes. It was meant to be being downloaded. What it is a note which seeks to respond to the questions by reference, but then it references both my learned friend's bundle and three additional materials that we have identified that may be of assistance.
It's a very substantial bundle. Has Mr. Knox had a chance to look at this?
My lord, I haven't actually, but I don't myself object to it going in as such, as long as, if there is anything which I haven't had time to look at and need to say something about, I can just put in a very short note on it after the hearing. From what my learned friend says, I don't think that's likely to be the case, but as I haven't seen it, I can't be too sure.
Yes, no, what we sought to do, and this is one of the reasons why it took a little more time, was we sought to not merely just stick in materials, but actually provide a sort of summary of what our answers to the questions is based on it. Yeah. It is meant to simply be an answer to the questions. I hope we've managed to get all the questions. If there's a question that is outstanding, then we'll try and answer that as well. But I hope we've managed to get all the...
From a very quick look at your note, it seems to cover much the same ground that Mr. Knox's materials cover. Does it actually add to those materials?
Well, firstly, it provides a summary of our position.
Right.
What it does is it adds one or two additional materials in the sense that it in particular, on a reading of Mr. Knox's notes, the material regarding criminal appeals didn't include anything which made it clear, which we would say is the position, that the Jamaican Court of Appeals jurisdiction is both to consider manifestly excessive and wrong in principle. And the Robinson case is an example of it considering wrong in principle, essentially.
Yes, I see.
The other two materials are just simply for completeness in relation to the question asked by Sir Declan Morgan. You have the Commission's report. The Commission was, as you have been were told yesterday, followed by two reports of the Joint Committee of Parliament, and those are the two joint committees of Parliament. We don't submit they add a huge amount, but for completeness, so that you can follow through, that's why they're there.
Yeah. Yes. It doesn't look from the note as if it's quite as substantial as it perhaps looked from the sheer size of the bundle.
Well, it's because of the attachments. It's only it's a two-page note, which is sort of certainly intended to be hopefully relatively non-controversial rather than sort of a substantive argument, effectively.
Yes. Yes, it rather looks as though there may not be much in it that Mr. Knox is going to be troubled by.
No.
If there is, obviously, you can respond in writing.
Yes.
I'm grateful, man.
But we were just concerned that if we're just stuck in the material, it didn't set out the answers to the questions, and that by what we were trying to do was provide an answer to the questions.
Thank you. Yes, Mr. Knox.
Can I first go to the material on sentencing policy? I hope I can deal with it relatively briefly. The first point is this, that the Court of Appeal's powers in relation to sentencing arise under an Act passed in 1962, and they mirror those of the English Court of Appeal, which were granted by the 1907 Criminal Appeals Act. And so what we've done is we've put in the 1907 Criminal Appeals Act and the Jamaican equivalent, and you can see at page 3 of the supplementary bundle sent over last night, section 4, subparagraph 3, you can see this is the English wording. On an appeal against sentence, the Court of Criminal Appeal shall, if they think that a different sentence should have been passed, quash the sentence passed at the trial and pass such other sentence warranted in law by the verdict, whether more or less severe.
Where are you reading from?
Oh, sorry, page 3 of the latest supplementary one.
It's actually page 4.
Is it? Oh, I do apologise. I better, you're right, page 4. Section 4, subsection 3. I'll leave it to the board to read it to itself. And then the equivalent in Jamaica is at page, I hope, 24, section 14, subsection 3.
Sorry, page 24.
24, section 14, subsection 3.
Your numbering, I'm afraid, is one out from ours. We have it on page 25.
In that case, I'm going to have to...
Confusingly, the printed numbers in the hard copy are one out from the
I'll remember.
electronic pages.
So, you'll see it's, I think I'm right in saying identical, save for one word, should, this has got ought, as opposed to should. That's it. So it's the same. So this is obviously modelled on the English provision. The case which is commonly relied on and cited in Archbold in relation to the Court of Appeal's powers and sentencing was Ball, which is at page, I think, 63. Do you have that?
Yes, sure.
And this was an appeal against sentence. Essentially, the appellant appeal, because his co-accused had been given a probationary, given only a probationary sentence, and he got 5 years, and he was upset about that. And you'll see the principle is set out in the first paragraph of Mr. Justice Hilbery's judgment.
Yes.
And just a couple of points. You'll note, actually, the wording used by Mr. Justice Hilbery is only when a sentence appears to err in principle, court will alter it, if a sentence is excessive or inadequate. He doesn't use the word manifestly. It's just excessive or inadequate. And then I obviously rely on what he goes on to say in the next paragraph about the public interest and so forth. The Jamaican authority, which would appear to have been the main authority which considered the position in Jamaica under the Jamaican Appeal Act, is the case of Clement, which starts at page 66, I think. Mm-hmm. And this was a case involving quite a bit of dishonesty on the part of the accused. The relevant passage is at page 92. Paragraphs 42 and 43, if I can just ask the board to read that. And the principles which they are talking about in those paragraphs are summarised at page 79, paragraph 20. Indeed, paragraph 20 to 21. And then sentencing guidelines we have at page 119. And these were made in December 2017, and they were the first to have been made in Jamaica. If I can just ask you to note a few things in this. Page 125, I think, you'll see a passage headed "The Objectives of Sentencing," and in particular paragraph 1.4. And 1.5. Up to 1.7. And then there's a short passage on prescribed minimum sentences at 131. I don't think it adds very much to what you've already seen, but I just mention it for your note. You'll note from 5.5 that they apply not only in relation to the Offence Against the Person Act, but also in the Sexual Offences Act and also the Firearms Act. So these are not entirely uncommon. At 137, 136, you see the sentencing process, and then that identifies how the process should be carried out, I think in fairly conventional terms. There is a passage at 137 on the starting point, which I should show you. 7.1, you choose an appropriate starting point, a notional point within the normal range. That's where you start. And then 7.4 follows the maximum period, is usually reserved for the worst, but won't be normally an appropriate starting point. And then 7.5, a list of usual starting points for particular offences is set out in Appendix A. I'll come to that in a moment. They reflect experience gathered over time as well as previous sentencing decisions of the Court of Appeal. It's expected that adherence to them will assist in the achievement of one of the key goals of sentencing guidelines, to achieve consistency and coherence. But then 7.6, the usual starting points are intended to be indicative only. And then over the page, on the next page, 136, you have a list of aggravating factors. And amongst those you'll see premeditation, attempts to conceal the evidence, use of a firearm or other weapon, use of violence, and then operating in gangs. And then mitigating factors on the next page, 139. And then you'll see the first three of those youth of offender, immaturity, mental state, and so forth, cooperation with the police. And so on. Then I should draw your attention to page 145, I think. Time spent on remand. And this basically sets out the general rule that you should take that into account. And then the appendix, and what I want to show you, these are the what you might call the starting points, and the ranges. As the relevant page for our purposes is 155. You will see the second entry down, shooting or attempting to shoot or wounding with intent to do grievous bodily harm, section 20 of the Offences Against the Person Act, statutory maximum, statutory minimum, if there is one, and it points out 15 years in the case of persons convicted of shooting with intent or wounding with intent involving the use of firearms, so that's the minimum. But then otherwise, the normal range would be 5 to 20 years. And the usual starting point, except for the statutory minimum, is 7 years. So the use of the firearm bumps up quite considerably the usual starting point, if I can put it that way. Rather, that's not the right way of putting it, is almost double, a little bit more than double the usual starting point. So I hope that deals in a fairly summary fashion with the points on sentencing that arose yesterday. One point we should add is that there has been a case, a reported case on section 42K, I think, which one finds at page 103, the case of Tafari Morrison. And broadly, this was another wounding with intent with a firearm case. And you can see at 103, paragraph 2, the judge sentences the accused to 15 years and so forth. And the judge basically said, she orally indicates, without actually giving a certificate, that she thinks that a sentence, she would have given him a credit for the 18 months spent on remand, but she basically says, well, I'm not going to give you a certificate for that, and so she doesn't. He then appeals to the Court of Appeal, and in fact it goes to a full court, not just a single judge. And then the full Court of Appeal essentially says, well, it was, I think if you go to page 116, paragraph 28, you can see the conclusion. That's the only case we've come across where you see the 2015 amendments in action. Yes, Mr. Riley points out, in this case the accused was under 18 years old. It's in the first paragraph on page 103. Before I continue with my argument, just a couple of points picking up on what happened yesterday. I said yesterday that I'd give you the reference for the purpose of the 2010 amendment being to tackle the high crime rate and the dangers created, or the danger of the safety of the public created by the use of firearms. The reference for that, and perhaps I can take you to it because there's another reference, is at page 214, paragraph 39.
Can I just ask you one question on,
Yes.
on the case that you pointed us to? Do I take it that the court at paragraph 30 was satisfied that the sentence of 15 years was manifestly excessive, having regard to the suggested sentence of 13 years and 5 months?
Yes, as I understand it, that's what happened, yes. In other
Whereas
words,
in this case, they concluded that a sentence of 15 years, and by comparison with a sentence of 12 years and 10 months,
Yes.
was not manifestly excessive.
yes, they did say that, yes. But also grossly disproportionate, not grossly disproportionate. But we've been
Talking
now.
about
But yes, that appears to be the case, yes. But that obviously wasn't a specific challenge under this Act. I mean, the problem we have is that no specific challenge was made under this Act in this case. But at page 214 of the bundle, paragraph 39. Oh, forgive me, I think I've given you a bad reference. It's in the Court of Appeal's judgment. I thought it was at 39. I've given you a bad reference for the Court of Appeal's judgment. My lords, I do apologise. Perhaps I can come back to that. Let me just check.
Court of Appeal's judgment in this case? Or?
Yes, in this case, yes. It should be there. For some reason, I've gone to the wrong page.
Yes, it explained that the sentencing judge imposed sentence before the methodology applicable to sentencing was summarised in Clement. Is that what you were referring to?
Yes. Page 85? I think it's page 85.
Yes.
Yes. Where's the tackle point? Tackle. This way. My lords, forgive me, I think I've just given you a bad reference. If Mr. Ryder can come up with it in a moment, I've given you the reference to our case, which talks about tackling, but there's actually the Court of Appeal citation. I wanted to give you that instead.
Sorry, is that on the reason for the 2010 amendment? That's what you wanted? Okay.
Yes, yes.
81, paragraph 30.
I'm grateful, it may well be that.
Page 85 is paragraph 30, I think. Or,
It's page, yes, it's paragraph 30 of page 81. And so you'll see, this is on behalf of the DSP, on behalf of the Attorney General, generally accepted had been imposed by the government in an attempt, quote, to tackle the high crime rate in the country and to reduce the threat to national security and public safety imposed by the increasing use of firearms. So firearms really were causing a problem. It's not just crime. It's specifically to do with firearms and their proliferation. So the amendments to both the Firearms Act and the Offence Against the Person Act to prescribe mandatory minimum sentences for offences committing using a firearm targeted the use of unlawful use of firearms and so forth. So that's the reason. In that context, there's one other statute I want to show you, or constitutional provision I want to show you, and that is section 48 of the Constitution, which you see at page 313. And it's obviously your lordships are familiar with it, but it is worth emphasising in a case like this what you might call the fundamental duty of Parliament is. Subject to the provisions of this Constitution, Parliament may make laws for the peace, order and good government of Jamaica. In one sense you might say that is this is right at the top of their list of priorities, salus populi, as it were, lex suprema. So we say it's entirely understandable that Parliament took this I accept, strong step, to meet what was seen as a very difficult problem. My Lord, I now want to turn to the question, to what extent can international treaties assist in interpreting the Constitution? Because my learned friend's argument relies heavily on international treaties. We say, first of all, the starting point must be domestic law, which is deliberately incorporated, in this case, only part of a number of treaties to do with the children. That's only part of, indeed a large part of, but not the entirety, of the United Nations Child Rights Convention. And I submit, in such a case, where there's already an incorporation, deliberate incorporation of part but not all of the treaties are relevant in two different respects. First, they're relevant to resolve textual ambiguities in a constitution or a charter, where they precede the constitution or charter itself. That's one use. And the classic example of that is Fisher. You look to what went before to decide what this word in Fisher, child, what does it mean? And once you go to that, then you've got the meaning for good. Child includes a legitimate child. Changing circumstances and changing morals can't change that later. You've got a fixed meaning by reference to a preceding treaty which can help you answer the question. That's one use of treaties.
And what happens where the underlying treaty is subject to living instrument interpretation?
Well, in those, I would suggest in those circumstances, the Constitution doesn't alter. In other words, what you're looking to do when you're resolving ambiguity is look to the words themselves, in this case, child, and you say, well, I can tell what the framers of the Constitution meant by the word child by looking at the antecedents.
But why wouldn't one say, if the framers of the Constitution have deliberately adopted something from an underlying instrument, knowing that that's going to be a living instrument, that they haven't equally accepted that the Constitution should live in the same way?
Well, if one can draw the inference that they have deliberately, if I can put it this way, taken a particular phrase from a treaty, then it may be the case that if the meaning attached to that particular word in the treaty is then altered, it may be, one could say, the Constitution is intended to move with the treaty. But in my submission, the starting point would normally be, once you've got a specific treaty, and you can say the Constitution must be read in the light of that treaty to resolve an ambiguity, the Constitution is then, the meaning of that word is then fixed. Because otherwise what happens is that the people's rights under the Constitution move, so to speak, without the intervention of Parliament.
Well, is 13.3K taken from the American Convention on Human Rights?
Well, or the ICCPR, and there are differences. In fact, it's slightly closer to the ICCPR.
But is the ICCPR, does that mean that affects the interpretation of that provision as time passes?
Well, in my submission, no. I'm going to come to the second way in which treaties can alter or have an effect upon the constitutional meaning. The second way, I mean, I accept there may be gradations and it may not be necessarily as tidy as I'm trying to make it, but broadly, this is what I'm saying. The second way in which a treaty is relevant is that it gives one a broad idea of the changing values of civilized countries in accordance with which one should give practical content to the generally worded provisions of the fundamental rights and freedoms set out in the Constitution. In a sense, they are more like evidence of what the practical content of, let's say, the cruel and unusual punishment provision is. They're not directly incorporated, however, obviously not, but they just give you an idea of what the changing or evolving standards of decency are. But in the latter case, when you've got generally worded provisions, there's no specific ambiguity, for instance, in what cruel and unusual punishment means. But in that latter case, the state has a margin of appreciation in deciding how much of this treaty they should bring into effect. They're not bound to bring all the treaty into effect.
I'm not quite sure I follow that point.
Well-
you're positing a situation where the Constitution uses something like cruel and unusual punishment. As I understood it, you were saying, accepting that evidence of what constitutes cruel and unusual punishment may be garnered from looking at international treaties that other states have signed up to, which shows where the limits are.
Yes.
But then you seem to say, well, my question is, why wouldn't that be the end of the process? You seem to be saying, oh, but then the state can do something else and depart from those.
Well, cruel and unusual punishment may not be such a good example, because there may be some punishments which, let's say, mandatory death penalty, which everyone accepts are cruel and unusual, just like that. But there are other treaties, let's say in our case here, the child conventions. I say that it is not the case that every aspect of, let's say, the international treaties is such that you have to bring it into effect in a local constitution by virtue of local legislation. Because your local legislation will not necessarily be, quote, unconstitutional just because you don't bring into effect the entirety of an international treaty. In other words, I can see there are some examples, like the mandatory death penalty, where you say, well, it's outlawed effectively. International opinion outlaws it. Evolving standards of decency mean you can't now effectively reintroduce the mandatory penalty. You can't claim a marginal appreciation for that. But in the sort of case we're dealing with here, where there are differing views as to what the evolving standards of decency are, and just how much you must bring them into effect locally, then the local legislature does have room for manoeuvre, if I can put it that way. You might, for instance, have a treaty that says life imprisonment, save in the case of murder, is unlawful. But the local legislature, in my submission, would be entitled to take into account their own circumstances and say, well, we're not going to follow that part of the treaty, and we will follow other parts of the treaty. Just as we say here, we're not obliged to bring into effect all the provisions in the treaties, we just bring into effect some of them.
Well, I wonder, could we look at Article 37 of the UNCRC just to see what you say was taken in and what wasn't?
Yes.
It's at page 479.
Yes.
First sentence is fine, no child should be subjected, etc. Capital punishment nor life imprisonment without possibility of release shall be imposed. If someone is subject to a life sentence in Jamaica, is there a process of review?
I don't know off the top of my head, but I'm pretty sure there is, yes.
If there is, then that would seem to cover that as well.
Yes.
Because there's no prohibition on a life sentence as such,
No.
as long as there is some form of review. No child be arbitrary or unlawful or arbitrary detention. I think you presumably say yes, you have that.
We have that, yes. And conform
Arrest, etc., shall be used only as a measure of last resort and for the shortest appropriate period of time.
Well,
what does appropriate mean in that context? Do you say you satisfy that or not?
well, the trouble is that there is room for manoeuvre in appropriate. What is an appropriate period of time?
In the context of gun crime being a major problem involving people of teenage age. But that's why I'm asking whether or not you're accepting that you're within or without the treaty.
Well, we haven't specifically provided by local legislation, let's say in the Child Act, we haven't provided in terms that the imprisonment shall be used only as a measure of last resort and for the shortest appropriate period of time. We haven't expressly provided for that. We have provided for the best interests of the child to be taken into account. But we've carved out an exception in the Child Act for offences under the Section 20 of the Act.
C essentially is the Child Care Protection Act.
Yes.
About circumstances and separation of children from adults, etc.
Yes.
Provide for. And D is about access to
Legal advice.
Which again, essentially you say, subject to the latter bit of B that you have,
Yes.
Jamaica has complied with Article 37.
Yes. And I'm not trying to say that you can just not comply with the treaty, but there is some margin of appreciation into the extent as to which you do so. And I submit that to Jamaica, if you looked at the Child Care Protection Act, you might say, and my learned friend I think probably does say, at least in the light of Section 13.3, that it doesn't go far enough. In my submission, it does go far enough, and it goes within the limits that it's allowed to do so, and it didn't have to go any further than it did.
Suppose that the 2004 Act had introduced corporal punishment as a big thing, which is outlawed as degrading under the ECHR at least. But that may have been something that the Jamaican Parliament thought was a better option than locking up 17-year-olds for a long time.
Yes.
Now, it may be arguable that that would be a breach of Article 37, assuming for the moment that it is, that it would be. How does that affect the young person's rights who are a young person who is sentenced to caning or whatever?
Well, I suppose his first port of call would simply be the Constitution itself. He would say this law introduced by Parliament, reintroducing caning, is inhuman and degrading. I mean, in one sense, he wouldn't necessarily need to go to the treaty. He would simply say, well, this law is inhuman and degrading, and it is outside your margin of appreciation because it's unconstitutional in the first place. It breaches my constitutional right in the first place. I see your ladyship's point, but I submit his route would be just a straight, I go to section 13, what if it's 13.3.6 or whatever.
I mean,
yes.
I would have thought that would be an example of the sort of thing I was putting to you, that, if the standard is inhuman and degrading, that can change with social values over time. It changes both for the treaty itself, but also for the Constitution.
Absolutely.
And if social values have moved to the point where caning of a child is not acceptable, however one arrives at that, possibly from looking at international evidence, but just possibly from sort of evidence of changes of social value, then you can say that is the right in the Constitution, and you rely on that.
I fully accept. Well, my argument is indeed that the Constitution, the practical content, I think is the phrase often used, of these general phrases like degrading and inhuman, does change over time. Of that there is no doubt whatsoever. And I accept also that you can look at international treaties to give you a good idea of what the evolving standards of decency are. I accept that too. But what I don't accept is that it follows from that you've, so to speak, got to incorporate to core all the specific provisions of the treaty. There is still, in my submission, a margin of appreciation. Now, you can't exercise that margin of appreciation in such a way as effectively to bring about a law in your own country which is cruel and unusual. For instance, the caning example might be an example of that. That's an extreme case, or a relatively extreme case, but I certainly do submit, on the other hand, that, for instance, the fact that there is no provision in Jamaica for prison in case of gun crime to be a measure of last resort, I submit is not something. It is something within, if you like, the margin of appreciation, which is allowed for. That's what it comes down to.
The courts aren't concerned with whether there has or hasn't been a breach of an international obligation. They're using the treaty as an aid to interpretation of the Constitution. The Constitution is supreme law. The Constitution can't be altered by domestic legislation. You can't alter the Constitution in that way. On the facts of this case, if 13.3K is to be interpreted as including the shortest appropriate period of time, well, the answer may be quite simply that is a qualified right.
Yes.
And it has to give way to the rights of others to be protected from gun crime.
Indeed, as the Constitution itself provides for.
Yeah. So the anxiety to prevent the incorporation, the evolving incorporation of the shortest appropriate period of time, doesn't have any practical effect in this case.
No, it may not make much difference in the end. I accept that, and that's obviously one of our arguments.
And how do you say that domestic legislation can alter the Constitution?
No, certainly. Domestic legislation of itself obviously can't alter the Constitution.
Well, I thought you were saying, well, they've chosen to carve out some aspects in domestic legislation, but they have omitted other bits.
No. They certainly can't do so in such a way as to infringe or bring about an infringement of the Constitution. But subject to that, they don't have to bring into effect every single part of a treaty.
But you look to the Constitution to see what it says.
Exactly. But the Constitution itself is not requiring, in my submission, let's say, take this case, is although you look at evolving standards, you look at the international treaties for the purpose of working out what the evolving standards of decency are. They don't all say exactly the same thing, and they're often phrased in fairly general terms themselves. And that's why I say that you don't have to, so to speak, bring in every single word for word of a treaty, as long as what you do bring in is consistent with what the Constitution already requires. But the Constitution doesn't require, because otherwise you land up with the position that a Constitution can effectively be changed by the executive entering into a treaty after the Constitution has been entered into. That can't be right either.
So if one tested it like this, suppose the power to order a young person to be caned was pre-existing law that was saved by Section 13(7) of the treaty of the Charter, it would not then be unconstitutional. You would have to read 13(6) and 13(3)(0) as subject to that law, and the fact that it retaining that may put Jamaica in breach of its obligations under the UNCRC does not give the young person a domestic right not to be subject to that punishment, would that be?
Exactly, and that was exactly the point really in Boyce in the death penalty cases back in the early 2000s. It was accepted by Barbados that they were actually in breach of, I can't remember which treaty it was, probably the American treaty, by maintaining the mandatory penalty. But there was a specific saving for it, and therefore domestic law was unaffected by the entry into the treaty.
Yeah, and again in the recent Chandler case.
The point's illustrated by the fact that when the European Court of Human Rights is considering a complaint that a contracting state has acted contrary to the Convention, and it refers to international law, it doesn't confine itself to treaties which that state has ratified.
Yes.
Because the significance of the treaty isn't normative in that sense. It's, as you say, it's evidence of the existence or not of a consensus as to what European values are, for example.
Yes. And my lord, that is my point. But the difficulty is sometimes these values round the edges are not entirely agreed. I mean, they may have a core value, which is
absolutely no consensus. Yeah.
But that round the edges, one might say, well, different countries have different views on this.
Governments will ratify. I mean, sometimes I get the impression that governments ratify treaties somewhat too readily without thinking about the implications in terms of domestic implementation.
Yeah. Well, there may be political reasons for doing it, but that's a different point.
All the relevant treaties in this case were ratified prior to the 2011 Charter.
I think that is right. And I think I'm right in saying maybe before the 2004 Act, but I'm not sure. But certainly before the 2011 Charter.
That brings me to one point. I noticed from your submission that the objective of the 2004 Act was broadly to bring in, so far as I can see, aspects of the UNCRC.
That's it, yes.
I didn't see in the material we had where that was stated.
The Court of Appeal referred to it in their judgment. I think from recollection.
Is there a preamble to
I think there is a preamble, but we haven't got it.
I think it would be helpful to see that.
My Lords, I don't propose to take it unless you wish to see it again. You've seen it many times, I suspect, in the past, recent past, the case of Minister of Home Affairs and Fisher. The point I want to make is, in that case, the question was, what is the meaning of child? I think for the purpose, because I think the appellant said she wanted to bring her children, or her children wanted to have resident status in Bermuda. That was broadly the idea, and they were illegitimate. And she said, well, child means illegitimate child as well as child. Therefore, they're caught by the Constitution. And the other side said, no, child means legitimate child. And I think it's the relevant page, is 330, it's 1182. You can see the opinion of board given by Wilberforce. But what he did, he looks at, quote, the antecedents to work out what does child include, a legitimate child. And essentially he looks at three antecedents which all preceded the coming into effect of the Bermudan Constitution, which came into effect in 1967. And the first was the ECHR, and he refers to Article 8, and that came into effect, and that was adhered to in 1953. The second was the United Nations Declarations of Rights of the Child in 1959, and the third was Article 24 of the ICCPR in 1966. And so what I submit Lord Wilberforce is there doing is at what you might call one end of the spectrum. He's specifically asking, what does this word mean, and answering it by reference to antecedent.
Well, I think you need to be a little bit careful about that, because if you look just by C, he's also referring to decisions on the ECHR.
Yes.
So you could have a decision that comes a little bit later, which makes it clear that, what the meaning of the word child is there.
Yes.
So I'm not sure that he's treating things as completely fixed in the way that you seem to be indicating.
Well, on the meaning of the word child, my lord, I'd say it's difficult to see how he isn't. Once you include illegitimate child, can I put it this way? It would be difficult to reduce the scope of the meaning of the word child later. In other words, let us say, for whatever reason...
Right, no, but it might have expanded.
I agree with that. I'm not excluding expansion. What I am saying is you can look at the pre-existing treaties to give you at least the scope of the meaning of the word child. It may expand, let's say, to include an adopted child or whatever. But at least it gives you that much. And to that extent, you look at pre-existing treaties and they fix up to a certain point what the position is. And let us say, for whatever reason, and it's highly abstract, that later these treaties all excluded the word, or all excluded illegitimate children from their scope for some reason. There was a crackdown or whatever. Then I submit the Constitution would still mean would mean child, including illegitimate child. In other words, later international treaties couldn't at least affect the scope, or couldn't reduce the scope of what child meant. That's the point I'm seeking to get at. The other point I'm seeking to get at is, to that extent, the meaning of the word child is fixed. It's not a matter of evidence. You're not looking at evolving standards so much. It's simply, you've got a fixed meaning for the word child in the Constitution. And so it wouldn't be much use if, say, the state of Bermuda sought to come along later and say, well, we've got a rather different view of the word, what the word child means, and evolving standards of decency mean we're going to exclude illegitimate children. The board would say, well, there's a decision here as to what this word means in the context of this Constitution, by reference to the standard method of looking at pre-existing treaties. And I say that's a slightly different, more fixed point than you get by reference to evolving standards of decency. My lords, my lady, I'm conscious of the time. There's just one point in Matadine and Pontoon, which is the case often referred to, saying you just look at international treaties and you interpret rights provisions by reference to them. In Boyce, Lord Hoffman did slightly row back on that, and a passage I think my learned friend took you to yesterday, which is at E766 to 767. And, my lords, it is in my submission, if I may go to it, it is quite an important point, this.
not sure that's the right reference.
Forgive me, that must be Matadine 12752. It begins at.
Sorry, is it paragraph 26 of Boyce?
Yeah, paragraph 26 of Boyce.
That's 767.
767. Oh, 767. The principle is at its strongest, and so forth. Its application to laws which existed before the treaty is more difficult to justify as an exercise in construction. And so at that point, some doubt is being cast over that proposition. And in my submission, that is right, because otherwise you do land up in the position of saying international treaties can actually affect the meaning of the Constitution, can bindingly affect the meaning of the Constitution, regardless, and that would mean the executive can alter the meaning of the Constitution, which seems an unlikely proposition.
Well, but that's a proposition Lord Hoffman here is prepared to contemplate and proceed on the basis of.
Indeed, yes. Well, my lord, it's because it didn't matter which way you decided, but he left the point open. That's my point. The point is, in my respectful submission, left open. My lords, if I may, I was involved in that case, and I remember how that point came up. And when that point came up, Lord Scott, I remember this very clearly, said that can't possibly be right. He was sitting next to Lord Hoffman. Anyway, that's how it came up. And so I do respectfully submit one has to be a little bit careful. And in a sense, I'm not saying international treaties are irrelevant, but they have two different types of relevance. That's my point. My lord, that's what I say about international treaties. And in this particular case, I say that it was open to Parliament in 2004 to bring into effect the provisions in the Child Care Act in the way that it did, so as to allow for the imprisonment of people over the age of 14 convicted of an offence under Section 20 and similar offences under the Offence Against the Person Act. That was, if you like, within their margin of appreciation. Can I just, in this context, please take you to, well, in Matadine and Pointou, Lord Hoffman himself, at 973, I think, envisaged that there was a margin of appreciation. In that case, at 973, I believe, in Matadine and Pointou.
And so can you help us where on the page
Yes.
you want to?
It's 973, and it's between C and D. The sentence actually begins at B. In conformity with this principle, the Human Rights Committee has held that a state party is not obliged to incorporate the provisions of the covenant into its domestic law, and the ECH, the European Court of Human Rights, has taken the same view of the incorporation of the European Convention. Furthermore, interpretation of the covenant allows, quote, a margin of appreciation to the state party in deciding what amounts to equal protection of the law, and there's no reason why that margin should be engrossed by the judicial branch of the government rather than the legislature or its executive. But I submit that the notion of a margin of appreciation would be entirely consistent in any event with the law as developed in relation to the European Convention.
Yeah, I mean, I'm not sure how far this is helping us in our case, but just on the interpretation of this, the margin of appreciation is specifically in relation to the implementation of a particular provision in the treaty. I mean, he's not saying whatever the nature of the treaty obligation, there's a margin of appreciation.
No, well, there must be some where there's no margin of appreciation. I accept that. I'm not saying that you've always got a margin of appreciation. It depends upon the nature of what the obligation you're bringing into local effect is. But there may be cases where you certainly do. That's the limit of my submission. I would also like, if I may, just to take you to the case of Lendor, which is at page 884, and the relevant passage is at 906. And we refer to this in our case, but I submit this is the correct approach to the interpretation of the Constitution, and indeed the interpretation of the Constitution in the light of international treaties. And it's paragraphs 59 to 60. If I can just ask you to read that yourselves, my lords, my lady. Now, this is obviously being said in the context of Trinidad and Tobago, and to what extent it should, so to speak, follow the twists and turns of decisions of the European Court in human rights cases. But I do submit similar principles apply here. We're not here dealing with the European Court or the ECHR, but we are dealing with international treaties. And the passage I particularly rely on, and I say is apposite, is about two-thirds of the way down the page on 906. Criminal law and procedure and penal policy in general are areas in which accepted practices are particularly liable to diverge as between different jurisdictions in different parts of the world where patterns of criminality, social attitudes to crime and the practical implications of penal policy may not be the same. And then it goes on to talk about the problem of Strasbourg cases laying down particular rules, saying when it's inappropriate, so to speak, to treat those decisions as applicable to Trinidad. And that's, in a sense, is my point. I mean, there is a limit to how much the specific rules in treaties or specific rules as interpreted or made by the courts should be transferred over by virtue of constitutional provisions such as the inhuman and degrading punishment provision.
On the facts of this case, one can readily recognise the Jamaican requirement to have different rules given the gun crime.
Exactly.
And but that doesn't potentially mean that you don't interpret the Constitution as taking into account the best interests of the child, or the child being sentenced for the shortest possible period of time, because that right has got to be balanced against whatever is prevalent in society in Jamaica.
Yes, that is right, my lord, yes. Well, I accept that. Can I also, just in paragraph 61, in the same case, page 907, they may bear, this is talking about the ECHR decision, about 10 lines down, they may bear valuable persuasive authority on general principles underlying protection of particular rights, but they are likely to be less valuable when prescribing the detailed contents of those rights or the mode of giving effect to the procedure. As far as the board is concerned, particular importance will generally be attached to the views of the courts below, before recognising any development of the law which is not warranted by the express terms of the Constitution or necessarily implicit in them. And again, we adopt that. And essentially, the deference to the local courts, we have a much better idea, indeed have to deal with gun crime every day, or every day.
Well, was Trinidad and Tobago in a different position? Because I thought that here it was accepted that Jamaica had acceded, or was treated as acceded to the ECHR on the UK's accession.
Yes.
But it doesn't seem to be the case with Trinidad and Tobago.
That's right. Well, I think Trinidad and Tobago did originally
Yes.
accede to it in 1953, but it followed a slightly different model of constitution. Whereas the Jamaican constitution, you can see the cruel and unusual punishment provision is, as I showed you yesterday, pretty well the same as in the ECHR. But there are obviously differences, and I think one of Lord Sales's judgment, I think, so you have to be very cautious about, as it were, introducing ECHR notions into these Caribbean constitutions, even though originally they may have originally derived something from the ECHR.
Well, what's said in paragraph 61 would be true of Jamaica as it is of Trinidad and Tobago, isn't it?
Yes, what's said there is absolutely the same, yes. So that's what I say about the incorporation, if you like, of all the different treaties which refer to the child. We say we did incorporate, and we're entitled to incorporate to the extent that we did. And we do also say, subject to a point I'm going to come on to, the 2010 amendment, Jamaica was entitled to, Parliament of Jamaica was entitled to pass that. There is a qualification I come to in a minute. Now, I do accept this much. It might be said that in certain cases the mandatory minimum could lead to a grossly disproportionate result. Now, I say it doesn't follow from that you strike down the law, or indeed that the sentence passed in this case was unlawful. The first point I make is this. In the generality of cases, wounding with intent with a firearm is likely to be a very serious offence, such as to require imprisonment for a substantial period of time. It may be harsh, but it's in many cases, but in most cases I respect it's not going to be inhuman degrading as such to impose the minimum term. But I accept that one might theoretically be able to come up with very hard cases, let's say a 14-year-old who is heavily under the influence of his older brother, who hardly knows what he's doing, but he does actually go along to the scene and then he shoots in a moment of panic or whatever. You can hypothesize certain cases, and I can see that there may be cases where one might say just 15 years minimum without reference at all to the circumstances or circumstances of offence. That's just too much. I can see that. My submission is this. It does not follow from that you strike the law down. The first point I make is this. We have, I think a few days ago, we served a supplementary bundle and a short note referring to the recent decision of the Supreme Court in the Northern Ireland case about abortion rights. And if I can ask you to turn that up, and I think it's at page 98 of the supplementary bundle.
Is this the same supplementary bundles we were looking at before?
No, I regret to say it's the first supplementary bundle, a different one in other words. It's at page 97.
This one begins on page 96.
This is the bundle with 153 pages.
Yes. Begins at page 96, supplemental page 96. And the question in this case was whether various restrictions on protest outside abortion clinics, or whether laws which prevented the restrictions on such protest were unconstitutional in the sense of outside the powers of the Northern Ireland Assembly. And you can see paragraph 3, well, I can deal with this relatively briefly. Paragraph 3, the attorney submits this provision as disproportionate interference with freedom of conscience in Article 9, and then Article 9 is set out. And then paragraph 10 on page 102, the submissions accordingly raise a question as to the appropriate test to apply when deciding whether a provision of devolved legislation is beyond legislative competence, on the ground that it is disproportionate interference with the convention right. They also raise a number of questions on other matters. That's the question. And then going over the page to page 6, paragraph 13, The court refers to the Christian Institute case, Supreme Court decision in 2016. And there is, for the general principle which you see recited, the court has explained that ab ante challenge to the validity of legislation on the basis of lack of proportionality faces a high hurdle. If a legislative provision is capable of being operated in a manner which is compatible with convention rights, in that it will not give rise to an unjustified interference with Article 8 rights in all or almost all cases, the legislation will not itself be incompatible with with convention rights. And then paragraph 16, there's a slight gloss that was put on that in a subsequent case called McLaughlin. In paragraph 16, you'll see a recitation which is said to be of what was said in the Christian Institute case. The last sentence you'll see Lady Hale in her judgment said, "It is enough that it will inevitably operate incompatibly in a legally significant number of cases." So there's a slight change in emphasis which is referred to in McLaughlin. And what the court did, it considered whether that was a justified change in emphasis, and it went back at paragraph 18. Be that as it may, in the last sentence of the passage in paragraph 16 above, Lady Hale cited Christian Institute as authority for the proposition that, it continues. But in the Christian Institute case, the critical words were, if a legislative provision is capable of operating in a manner which is compatible with convention rights, in that it will not give rise to unjustified interference with Article 8 rights, in all or almost all cases, the legislation will not be incompatible. And then the court goes on to say the test in Christian Institute is the correct test. Now, what I say by imperative reasoning, if you have a statute which in all cases or almost all cases is going to be unconstitutional, it's going to result in an unconstitutional result, then you knock it out, if I can put it that way. When it comes up before the court can say this is never going to be compatible, or hardly ever. But subject to that, then the proper course is not to strike the legislation down. You apply it, but if it will lead to an unconstitutional result, then in those cases, as in this case the Court of Appeal did, in those cases you apply the legislation if it doesn't lead to an unconstitutional result. But if it will lead to an unconstitutional result, then you simply say, well, I'm not going to apply the legislation in this case. And I will treat it as...
Isn't that exactly the approach taken in Gangazing at page 854, paragraphs 36 and 37?
Exactly, yes. And I say this is the
Isn't it also the approach that was not adopted in the abortion safe zones case, because that would lead to the court dealing with the criminal trial having in each instance to address the constitutionality of the punishment,
yes,
which was the argument that was rejected in the abortion safe zones case,
yes,
as a reason why a provision would not be unconstitutional, would not be outside competence. It was said it won't be outside competence because every time you apply it, you have to decide whether it's proportionate or not. But this court said, no, that's not the right way to go about it. You have to look at the legislation and decide whether it is setting something which is of itself compliant.
Well, as I understand it, this case is saying that you don't knock out legislation in advance, so to speak. You don't declare it to be incompatible or unlawful, incompatible with the powers of Parliament, unless you can say that it always or almost always will be so incompatible. In other words,
I think you may both be right in a sense, yes, in that we were dealing here with a preliminary issue of what is the appropriate test.
yes,
But at the end of the day, we decided that there would not be an incompatibility,
yes,
because the balance struck between the competing interests was a justifiable one, even if there might be some cases which might be regarded as rather one might say, rather hard cases, that was tough luck.
Yes. Well, I submit that is, if I can put it that way, the general principle which should be adopted in this case, if one thinks that in certain cases this type of statute, or the 15-year minimum, is likely to result in an excessive punishment or grossly disproportionate punishment. There's not a sufficient justification for striking the law down. That's my basic point. If the law can be given effect in most cases, or at least some cases, a sufficient proportion of cases, then you let the law stand. But if you come across a case where that law results in a grossly disproportionate result, then you read it down to be a recommendation.
I mean, I would have thought that it matters what scheme of protection exists for constitutional rights.
Yes.
So, I mean, the Northern Ireland abortion case was concerned with whether a law could be passed in the first place, and whether there was competence for the court, for the local legislature to do that. But I would have thought that in the context of the Jamaican constitution, where, as you pointed out, under Section 2, a law is treated as void to the extent of inconsistency, and where you have the ability of an individual faced with the application of the law to them in their individual case to raise their constitutional rights, that the way that their constitutional rights are then protected is by the court enforcing them at the point when it's invited to apply the general law which has been passed by Parliament.
Yes.
And if the constitutional rights of the individual can be protected in that way, all the more reason why one wouldn't go back and say, well, we can imagine a case where some individuals' constitutional rights might be infringed by application of this law, therefore strike down the whole thing, even though it's perfectly acceptable in
your case,
many cases. So I think it makes some significant difference, the way in which one can enforce one's constitutional rights.
My Lord, I adopt that, obviously, and we do, it's the Section 2 point, essentially.
Yeah, I'm certainly not saying that that's wrong, but we also have to have regard to 13.2b, which says that Parliament shall pass no law which abrogates, abridges, or infringes the rights.
That, of course, is in the Charter.
Yes, that's what I'm looking at.
2013.
Yes.
As opposed to the 1962 Constitution.
Yes.
Now, I can't remember off the top of my head what the 1962, what equivalent provision, if any, there was in the 1962 Constitution.
Yeah.
But, my Lord, I would say you still get to the same result. To the extent that Parliament has done that, then you treat the laws valid, or save to the extent of the inconsistency with the Constitution.
Yes, I see.
This problem,
as I understand it, the cases that you're concerned about are cases which are not grossly disproportionate, because that would be caught by the Constitution.
It would be caught by anyway. By
yes, it would be caught. Yes. So it's really the cases you're talking about are cases where one might have thought that there was. I mean, I think one has to be careful about using the word proportionate, but where the sentence was excessive, if I can put it that way, but short of grossly disproportionate.
Well, if the sentence is merely excessive, then it's not unconstitutional, yes, and therefore Parliament can pass that law.
Yes.
The problem arises, supposing this could give rise to a grossly disproportionate result in a given case.
But surely that's caught by 13.6.
Exactly. In those circumstances, my submission is simply this, that the accused in that case can say, this punishment is grossly disproportionate, it's cruel and inhuman, therefore you cannot enforce this law against me. But that is the limit of it. And the court, in those circumstances, will say, I agree with you, or disagree with you. If the court agrees, it strikes the sentence down, or doesn't pass the sentence. If the court disagrees, then it can pass the sentence, regardless of the fact that in a different case, it would have been unconstitutional to do so. In other words, you do it on a case-by-case basis. You don't just say, this law is unconstitutional. I know it's perfectly okay for you, but I'm still going to strike the law down. That, in my submission, is wrong. And this problem has arisen in Canada, I may say, on quite a few occasions. And I just want to show, if I may, briefly, a Canadian case which deals with this problem in the context of the Canadian Charter.
And sorry, just before you go
Yes.
there, just on the section 13(2) point, I mean, section 2 of the Constitution is general, as I understand it.
Yes.
And it contemplates that a law may have been passed which is inconsistent with the Constitution,
Yes.
which then falls to be disapplied. So I'm not sure that one necessarily reads section 13(2) as saying Parliament can't, it's just void if it's acted in a way which is incompatible with the rights, because the Constitution itself in section 2 seems to contemplate that there's some, if you like, provisional lawfulness, but then it can be tested in individual cases.
I'm thinking about it. We've had cases under the Human Rights Act domestically where there's an incompatibility in the case of particular individuals, and we haven't then struck down, I don't think, the legislation as a...
My Lords, for what it's worth, I'm just taking a very quick look at the 1962 Constitution, which strictly speaking would be the relevant one in 2010, and that is at 278. I don't think there's actually the equivalent provision of Parliament shall not, which you find in the 2013 Charter.
Sorry, what was the page number you gave us?
Page 278, but I'm not sure we've got all of the old provision, but I am not sure, just from looking at this.
I'm thinking, for example, that there's a case called the Queen on the application of R, where the incompatibility concerned the application of subordinate legislation to the claimant. And the court's solution was not to declare the legislation ultra vires, but to direct the body applying it to disregard it in the case of the claimant.
Yes.
And presumably people in a like situation.
Yes. Well, I submit that's the right approach.
But one can't push that too far, otherwise no law would ever be unconstitutional, because you would always say, well, if it's unconstitutional, it won't be applied in the particular circumstances, so it's always going to be fine.
Well, I agree. If that's why I say, if you can tell it's always going to be unconstitutional, then the court can just, as with the mandatory death penalty, after all, you just say, well, it's unconstitutional, and that's settled for the future. But there will be other cases where the law will not necessarily operate in an unconstitutional way, and indeed, it won't be very easy to tell. In those circumstances, and this is what the Canadian case I'm going to take you to suggests, you should uphold the law and allow for the case where, if it's going to be grossly disproportionate, then you treat the mandatory minimum as effectively a recommendation rather than a requirement. And that is what the Canadian courts have done in a case I would like briefly to show you, which we refer to in our case.
Just before we move on to that, what Lord Reid has said has jogged my memory as well. There's a case, I happen to be the one that wrote the judgment, which is Queen on the application of Z and Hackney London Borough Council, where the question of the operation, I think it was of Section 3 of the Human Rights Act in relation to a particular provision was considered, and previous authority was referred to, and basically the solution arrived at was, as my lord indicated, insofar as there was, one could imagine that some people might have rights which might be infringed by this legislation. That wasn't good enough to strike down the whole legislation for the benefit of someone who was not within the scope of those rights, who could not say of their own rights that they were being infringed. So sorry, I just mentioned that as a possible another example.
Was that?
Oh, may have been EU rights, but I mean the issue is basically the same. sorry, I can't now remember if it was convention rights or EU rights. I have a feeling it might have been both. I'm sorry, I
Yes,
just
it's
can't remember.
concern of discrimination, so there's an overlap, isn't there?
Yeah.
Equality law.
Yes, that's right.
Article 14.
I think it might have been both. Sorry.
No, not at all. If I may go to Morrissey, which is at page 1997, and if I can just give you some references, but take you to the most important passage. Essentially, what happened here, this was a statute which provided, which dealt with, which made it a crime to kill someone by criminal negligence. I think that was the idea, criminal negligence. It provided for a 4-year statutory minimum, and it was held on the facts that actually the sentence was perfectly appropriate. But the court did discuss this problem of minimum sentences and what happens if they might go, in some cases or reasonably foreseeable cases, they're going to lead to unjustifiable results or unconstitutional results. And the relevant holding, perhaps on page 1998, you can see basically the facts. The accused pleaded guilty, about 10 lines down, 1998 in the English version. The accused pleaded guilty, spent 5 months in custody, and so forth. And the question was the 4-year sentence excessive? And you'll note the appeal was dismissed, save for an adjustment of pre-trial custody. The ruling which I particularly want to, or the passage I particularly want to refer to, is that which is summarised at page 2000 in the judgment, concurring judgment, but for different reasons, of Justice McLachlan and Mr. Justice Arbour.
Page what, sir?
Page 2000, at the foot of the page, per McLachlan and Arbour, JJ. And just for your note, the head note continues, the relevant part of the head note continues down the left-hand column of 2001. The passages I wish particularly to take you to, which discuss this problem, what do you do with mandatory minimum sentences, but perhaps while I'm on it, page 2015, a rather useful description of what I submit inhuman and degrading punishment is. This is in the judgment of Mr. Justice Gonthier, cruel and unusual punishment. You'll see here a test, which I submit gives one the difference between that and manifestly excessive.
So sorry, where are you now?
2015, paragraph 26. Such that Canadians would find the punishment in abhorrent and intolerable, a sort of local horror test. But the passage I particularly want to put on in the context of this argument is at page 2034, and at the first main paragraph from 2034, the judges discussed the problem of foreseeable cases, because there had been other cases where laws had been struck down on the basis that they could reasonably foreseeably lead to completely unjustifiable results. But the more important paragraph is the second, or the last paragraph on this page. As the law now stands, under the first stage of the Section 12 constitutional analysis, if a minimum penalty is grossly disproportionate in one case, the provision creating that mandatory penalty is struck down as a violation of Section 12. That would be the inhuman treatment provision. This approach was developed in cases where the offence which attracted the minimum penalty was very different from that in issue in the present case. I believe that in order to give effect to Parliament's explicit desire to increase penalties for firearms-related offences, while recognising the inevitability that a 4-year penalty will be grossly excessive for at least some plausible future manslaughter convictions, a different approach is called for. I would therefore uphold the constitutionality of Section 228 generally, while declining to apply it in a future case if the minimum penalty is found to be grossly disproportionate for that future offender. Accordingly, I would dismiss the appeal and suggest a more individualised approach. That is essentially the conclusion. There are, just for your note, I'm conscious of time, paragraph 75 on page 2039 to paragraph 76 on 2041 continues the argument, and then paragraphs 80 to 82 at 2043 give the conclusion, but all to the same effect. And I submit here, in this case, that this is the approach you should adopt. You take the, in a case where it would be disproportionate to, or grossly disproportionate, to apply the minimum, i.e. cruel and unusual, then what you do is you treat the requirement as a recommendation, and it has some inflationary effect in the sense that the judge must give effect to, or as far as they can, give effect to Parliament's intention that this be treated as a especially serious crime. That, in my submission, is the correct analysis.
And is that the correct analysis even after the 2015 particular mechanism was enacted by Parliament?
Yes, I would submit that would be, on the face of it, yes, that would be right, because otherwise the court would be being asked, we get back to the debate we had yesterday, the court would be being asked to pass the grossly disproportionate sentence. The similar problem arose in the case Lord Stevens referred to a moment, called Gangasin, Albalik and the State of Mauritius, which is at E843, paragraph 37 onwards. There were a number of alternatives, and the court decided not to strike the law down, but simply to reduce the penalty. And there is a useful discussion in that case of the whole problem which arises in these types of cases. But I submit, again, that is the same approach which should be adopted. I think that was a 3-year minimum for dealing in a small way with cannabis, and the Privy Council held, well, that's just excessive, it's arbitrary and inhuman. So, my submission is this: there is no basis to interfere with the Court of Appeal's assessment that a 15-year minimum was not grossly disproportionate on the facts of this case. I just want to say something very briefly about the Section 3 point. I've covered many of the points already. It may be helpful just to have the provision open in front of you. At page 241, I think. 242. The right of every child to such measures of protection. And what I say is this, a fundamental submission is this: I submit as a matter of principle that as long as the sentence imposed in this case was not grossly disproportionate, so as to constitute inhuman and degrading treatment, it is not open to the appellant to attack it for lack of constitutionality by reference to Section 13(3). The reasons I say that as follows. These words are brief, and in my submission it is impossible to say that they intended to bring about the wholesale incorporation of the specific protections for human rights, the child's rights, found in the various international treaties, given that Parliament only 7 years earlier had decided not to bring into effect all the express terms of those treaties. Second, as far as these words go, their purpose is not specifically directed towards the question of punishment for crimes. That is something dealt with by the inhuman and degrading treatment provision. Also, we do have the Commission report, which rather suggests that the purpose of the introduction of these words was not specifically directed towards crime or anything of the sort. And we do have that in this most recent supplementary bundle we sent over at page 194. Oh, maybe 195. This, I hope, the report itself begins, I should say, at page 183, I think, February 1994. I should say in passing, 195, subparagraph, or paragraph 1 at the top, you'll note that the framers are keen to make it clear that the genesis of the fundamental rights is not confined to English common law, but encompasses universally accepted human rights. And then 197, you'll see they deal with, in paragraph 17 and 18, the child provision. I can just ask you to read that yourselves.
I see, and then paragraph 18 is the one that
Yes.
concerns K1.
Against abuse and exploitation. That's the real, well, that was the underlying purpose.
What do they mean by abuse?
By others, not so much by the criminal system, but by other people. For instance, I think you have to read it with the word exploitation, for instance, using child labour and things like that.
Can you help with the difference in language between this and the ICCPR?
Well, the ICCPR we have, I hope you have right at the end, there's the ICCPR and the ACHR. And the ICCPR we do have right at the end, Article 24, I think. I don't know if it's in the same bundle, but we noticed it wasn't in the bundle, but we do have Article 24, and I hope you've got it. Article 24, if I can read it. Every child shall have, without any discrimination as to race, colour, sex, language, religion, national or social origin, property or birth, the right to such measures of protection, identical, as are required by his status as a minor on the part of his family, society and the state. That's Article 24.
Yeah.
So what page is that at, sorry?
Well, it is in the bundle, which I think is an attachment we sent over yet.
I think it's
We had it yesterday.
Yes, it's
We were looking at it yesterday.
ACHR yesterday. For some reason, this provision wasn't in the provisions to do with the UN. We have sent it over. Whether it's arrived, I don't know. So it does seem to mirror Article 24, or that particular passage in Article 24. As far as the ACHR is concerned, that's at page 475 of the existing bundle. And that Article, I think it's 19. And you'll see it's in very similar terms, except it says the measures as opposed to such measures. We do have in the supplementary bundle we sent over this morning at 272 the commentary, the 1989 commentary on Article 24, which again we suggest indicates that it's not really talking about crime or crime and punishment as such. I think I said 272, maybe it's 273.
This is in the most recent supplementary bundle.
My lord, yes.
223.
Ah, 223, forgive me, my lord. Yes. And I think my Lord Reid read out some of this yesterday. It's really the second and third paragraphs and the fourth and sixth paragraphs that matter.
The second paragraph refers to the other provisions of the ICCPR that apply in relation to juvenile justice.
Yes. paragraph 3 in particular is about the individual states to decide how to deal with the point. And in a sense, it's Lord Hughes's point in Lendal. One must allow for different domestic policies. And paragraph 6 again. So, my Lord, I say this doesn't support the conclusion. These words, these rather short words you find in the Constitution, are really in any way intended to deal with punishment as such. It may be intended to deal with keeping separate from adults, one can understand that. But this supports the notion that this is a generalised phrase, dealing with general protections for the children. And that in turn makes it unlikely that the framers of the Constitution intended it, so to speak, to be some sort of add-on to section 13(6). Or separate right for a separate method of attack. If I can just briefly, in a minute, just give you my other submissions on the section 13(3) point. My second point is this: I've already made it in passing. I say the Court of Appeal, in any event, took into account the fact that the appellant here was a child, gave him, it appears, 2 credits for the point. That, in my submission, was sufficient. Started off with a 15-year starting point instead of 20, and it then also took that point into account again as one of the mitigating factors. Third, my third point, again a point I've made, the rights granted by section 13(3) and 13(3)k are not absolute, but are granted save only as may be demonstrably justified in a free and democratic society. That's section 13(2). It is demonstrably justified in my submission to impose very severe sentences for gun crime on 16-year-olds.
Well, I mean, usually, if one was looking at objective justification of the law, one would have a lot more evidence than we've got to enable us to assess that sort of argument.
Well,
up till now, it didn't seem that the state had mounted an objective justification defence.
Well, in the Court of Appeal, of course, the point is made by the Attorney General that what the genesis of this provision was. That's to say the 15-year minimum.
Right.
So she does.
So where in your written case do you deal with objective justification?
Well, I refer to. I think I do refer to this point actually in towards the end of our case. We do say as required by. I can't remember precisely where, but this is not a new point. It is. The trial counsel. The point is accepted.
I mean, I'm just saying that usually when you're dealing with objective justification of the law, we'd have evidence put forward as to what the scale of the problem was, and
but there's none of that.
No,
I accept that. But of course, in Jamaica, of course, the courts will know anyway. And if it comes from the Attorney General explaining what the position is,
right,
and they will know about it. But I accept.
Well, they may do, but they haven't given any judgment based on objective justification. So, in effect, you're introducing it to us de novo without any materials.
I certainly accept I'm introducing de novo. I'm simply relying on the material put below, and which the court would have been well aware of, and what the Attorney General said in terms in the court below.
It's in the trial transcript. In plea of mitigation.
And I think it's also in the trial transcript in plea of mitigation, my learned friend points out.
Oh, fine.
Okay. But anyway, that's what I say. And then my next point is, in any event, is that it's trite. I say that the best interest criterion is not a trump card. We deal with this in paragraph 89 of our written case. It can be overruled, it can be outweighed by other more pressing considerations. And we refer to the case of Naidiki and ZH in Tanzania. My learned friend, Mr. Wright, points out page 56. It goes back to the reference which I took to you right at the beginning, the enormous damage these crimes have done to the country. So I accept my Lord's point that there's not perhaps a plethora of evidence, but in one sense everyone knows what the nature of the problem was, which caused this legislation to be brought into effect. So that's what I say about section 13(3)(k). It doesn't essentially add anything if I'm right about the cruel and unusual punishment or inhuman and degrading punishment. My Lords, those are my submissions, unless there's any question which...
I don't think so, Mr. Knox. Thank you very much. Mr. Stunney.
My Lords, my Lady, rather. Before I start my submissions, can I just mention, in response to the sort of discussion that was taking place about cases where the court has not has not struck down legislation, the court may, and I haven't had a proper opportunity to look at it, but may also remember the P. or Gallagher case, which was the enhanced criminal records case, where there was the secondary legislation where there was an issue as well. So that may also be of some relevance. Can I then turn to the substance of my learned friend's submissions? My learned friend started by making the point, which is not in dispute, that obviously what is an issue in serious crime. But there is a critical difference in our submission between the fact that serious crime is in dispute, which we accept and have never argued otherwise, can require lengthy sentences as a response, and the disapplication of the rights of the child, because our point is not that you can't impose lengthy sentences. It is that if, when doing it, those rights need to be respected, and those rights are absolute, and those rights require best interest to be taken into account. Doesn't mean other things can't be taken into account and weighed in the balance, but best interests remain. They are effectively an absolute right, however they're stated in instruments. In that, following on from that point about the seriousness of the offence, my learned friend emphasised the fact that the Court of Appeal had concluded that the sentence was not wholly disproportionate. I'm going to come on to what we say that means, because the argument about the parallel universe in our submission is of some significance potentially, and I'll come on to that in a moment. But it is important to remember, as I drew attention to when looking at the principles applied in rejecting the Canadian and South African case, if one looks at para 64 of the Court of Appeal's judgment, which is at page 97, there is an express rejection, essentially, of the principles that we submit are clear in relation to children's best interests and shortest period. And at para 67, there is an express rejection of the argument that children should be treated differently. Now, consistent with that, you have now the 2017 guidelines. The 2017 guidelines, which are in the most recent Respondent's bundle, we've been through them to look at the references to children. There are references to the CCPA at page 127 of the bundle, paragraph 3.6, which deals with non-custodial sentences. In terms, though, of custodial sentences, there is no suggestion, for example, that normal guidelines should be departed from. And that, of course, is the approach of the Court of Appeal in this case. It was, when looking at the guidelines, it was to apply the bottom end of the guideline because of the age of the appellant. It wasn't to consider whether they should be disapplied. Now, my learned friend says the Court of Appeal took account of the position of the appellant as a child. We would say that they didn't take account of welfare, but in any event, that was only when assessing the notional sentence. It wasn't when assessing the 15-year sentence. The sentence they concluded, they reached, applying or giving consideration to age, was obviously less than 15 years. Now, that's the context partly in which we say one should be very cautious in any event about what was said about manifestly excessive and whether that is essentially a finding that an appeal in this parallel universe where there is no minimum would have been allowed. If the trial judge had approached matters in the way he did, which was discounting guilty plea and age in circumstances where there was no minimum, that clearly would have been an error of principle, as the Court of Appeal recognised, because they recognised that they were factors to be taken into account. Had there been such an error of principle, Robinson, the authority that we've included, demonstrates that there would have been resentencing. It wouldn't have been simply there was no consideration in Robinson where there was an error of principle as to whether the sentence was manifestly excessive. They simply resentenced because there'd been an error of principle. So if the trial judge had adopted the approach he'd done in this parallel universe where there'd been no minimum, the Court of Appeal would simply have resentenced, and one knows what would have happened because they indicated their sentence would have been 12 years and whatever it was. The alternative way of looking at it is that, of course, what is probably would have happened in this parallel universe is that the judge would have set a lower sentence, because that's what he indicated. He indicated that he would have taken those factors into account. If he'd set a lower sentence, at that stage, of course, the Court of Appeal would have deferred to his judgment, because that's what manifestly excessive is about. That's what the authority, my learned friend includes in his bundle Morris, indicates at paragraph 11. But the implication, again, is that the sentence would have been lower. So what the Court of Appeal is talking about in our submission when it talks about the sentence not being manifestly excessive is it may be talking about whether or not the sentence was grossly disproportionate, because clearly comparing a notional sentence correctly imposed with the actual sentence may be relevant to that. It may have been looking at whether or not the 2015 Act applies, but it certainly can't have been in our submission assessing what the outcome would have been on an appeal against the 15-year sentence in the context of this parallel universe where there is no minimum. Because one way or another, it's clear the sentence would have been lower. My learned friend then went on to argue that the weight to be given to the best interests of the child depend upon age. In our submission, there needs to be care adopted in relation to that submission. The primary consideration principle clearly applies to all children. That is clear, for example, from Article 3 of the UN Convention on the Rights of the Child. It's clear from ZH and Baroness Hale's judgment. Now, that doesn't mean age doesn't matter. Age will factor into things like maturity, which can be taken into account. Age will factor into things like the importance of deterrence. Deterrence potentially carries greater weight when the child is older. But it doesn't mean that one can disapply the principle of best interest of the child. Nothing in our submission in any of the international instruments supports that approach. My learned friend then, having made that submission, took you to the legislation that predates the CCPA. And that, for example, drew attention to the fact that the historic position was that Jamaica drew distinctions between young people at different ages, at different point in relation to different matters. Our submission is that in relation to that, we still struggle to see how that pre-CCPA legislation assists. Whatever the position before the CCPA, as my learned friend I think fairly accepts, clearly defines a child as being under 18, and that reflects the international consensus. And the CCPA also demonstrates, as my learned friend argues, a general intention to comply with the UN Convention. And so effectively demonstrates from that point onwards that there are efforts being made to implement the UN CRC rather in Jamaica. Now, my learned friend says in relation to the UN CRC that it carves out exceptions, and so he made a point at the submission, for example, about how the definition of best interests it doesn't include any reference to factors that might be relevant in a criminal context, and so suggested it might not apply in a criminal context. First point I should make about the CCPA is that, of course, it's important in our submission not to focus, in one sense, on the CCPA. The Charter follows it and was plainly intended to enhance rights. One way it did that was by making express reference to the rights of the child for the first time, and it was an addition. The key question then that arises in our submission, because it's the Charter that determines the legality of this legislation, is whether the Charter was intended to be more restrictive than the relevant provisions of international law that we've referred to. But in any event, even turning to the points made about the CCPA, Article 3 of the UN Convention doesn't reference crime in particular. And one reason for that in our submission is that the proper approach, again, to best interests is the one I've already advocated for, which is that you take account of best interests, which are child-centred factors, as seen in Section 2.2, and you then balance that against criminal factors. And that's why Article 3 can be applied in all circumstances. All it's indicating is that there is a factor of great weight that has to be considered. It doesn't suggest other factors can't be considered.
Sorry, Article 3, are you talking about?
Of the UN Convention, that's the best interest. Sorry, I'm...
And the page number?
Sorry, yes, it is... the UN Convention is... the UN Convention is at page 478 in Article 3. Article 3 is, what I would say, just in passing, I've been referring to Article 3 almost as a shorthand at that point in time, but it's important to recognise at the point I made before, I think, at least once, which is that, of course, Article 3 is one statement of that principle. It's an important statement of that principle, but ZH makes it clear that that principle is repeatedly stated in a number of instruments. It is a widely expressed principle. The third point I'd make is in fact, a demonstration of how the CCPA is intended to apply international standards to the criminal context as well as elsewhere. Of course, Section 65 expressly applies to all courts. And our submission is, I mean, my learned friend submitted essentially that there would have been no inconsistency between the CCPA and the UN Convention when it was enacted. I mean, in one sense, that's probably quite a difficult issue for the court to resolve, because obviously there's a lot of potential issues that arise. But in relation to this particular context, we would agree, because Section 65 specifically required the best interest to be taken into account. That allowed, we would submit, the other principles of international law to be taken into account. The issue arises essentially when the 2010 Act is enacted. Now, my learned friend says, and we don't dispute the intent of this, that the 2010 Act was then enacted to address serious crime. And we don't dispute that's the intent. We don't dispute that it is legitimate essentially for a state to enact legislation to address serious crime. What though that purpose or that submission by my learned friend fails to do is it fails to identify any reason why children are not treated differently, and in particular why consideration isn't given to the best interests of the child. Serious crime can require draconian sentences, that's clear, but there is a specific issue here which is not fundamentally as much about the length of the sentence, it's about what isn't considered. And that's not, there's nothing that identifies why children can't be or aren't treated differently, why account can't be taken of that. And it goes back to the point Lord Steckland Morgan made. We don't dispute that you could have a guideline here saying 15 years, but the issue arises when that becomes a rigid rule that prevents best interest being taken into account. And that isn't justified in our submission on the material. There's no material that justifies that. Turning then to section 13.3k, my learned friend made a number of submissions about that. His starting point is that section 13.3k is in very broad terms. But the drafters in our submission would have known that in those circumstances, as made clear in paragraph 29 of Boyce, which is page 768, broad terms required judges to provide detail. And in doing that, they will firstly adopt a generous interpretation, but more importantly, will construe broad terms consistently with international human rights instruments, unless there's a clear prohibition on doing that. As a consequence, in our submission, the general terms support the appellant's arguments. If Parliament had intended, when enacting the Charter, to carve out some limitation, the approach in Boyce in our submission means that essentially that would needed to be express. Now, in terms of the history of the legislative provision, you now have the Commission report. We've handed up as well the two joint committee reports which follow on from that. They're there for completeness. We don't submit the joint committee adds anything because they basically just endorse the Commission. The important point, the first point we'd make about that is that none of that material explains the language. The language, the origin of the language in our submission is not addressed. And that's in one sense why it might be said the Commission report is perhaps of less value than it might otherwise be, because in the absence of any material, in our submission one is left in the position that we have always adopted, or we've made, which is this language does, on the face of it, appear to reflect international instruments, and there's no reason to believe that's not the case. One thing that potentially supports that point is a point that my learned friend drew attention to briefly, which is that in the Commission's report, it is said that redrafting was intended to ensure that rights are not confined to the English common law, but reflect universally accepted human rights standards. In one sense, how does one assess those? One assesses those which is consistent with the language by looking at the American Convention and by looking at the ICCPR. One also, probably more importantly in one sense, takes account of the fact, going back to the point I made a moment ago about ZH, that of course the position in relation to best interests is now one of the most widely accepted provisions of international law. It's repeated in a number of treaties. it is clearly in our submission a generally accepted principle that it's pretty unlikely the drafters would not have been aware of. One also needs to take account, of course, of the ratification dates. And, for example, the American Convention was ratified on the 19th of July 1978, so would have been well aware, would have been something that the Commission would have been well aware of. My learned friend then points to the provision that says it was desirable to provide children with protection against abuse. Firstly, that, again, doesn't explain the source of the language. Secondly, it raises the question of what is meant by abuse, the question I think my Lord Stevens asked. Now, my learned friend's response to that is to say it's concerned with issues like child labour, but it's clearly wider than that. It refers to the state, it refers to other bodies. It is clearly intended to be a pretty wide-ranging provision. And that's why in our submission, when understanding what that widely phrased provision is meant to mean, one should go to Ferguson, page 655, para 17, which makes the point that where rights echo convention rights, they should be read in accordance with jurisprudence relating to the convention. And my learned friend says, in relation to that, Section 13.3k in particular is not intended to govern punishment. But as I say, the answer to that is it is intended, we submit, demonstrated by the language to reflect broad human rights standards. And those human rights standards include, for example, Article 37 of the UN Convention, the provision that talks about penalties being for the shortest possible period. And nothing, it goes back to the Boyce, the long-established approach to interpretation. Nothing indicates an intention to prevent international human rights standards applying. Far from it. The indication appears to be an intention to adopt the standards that apply in Jamaica. My learned friend placed some weight on Article 24 of the ICCPR. I mean, the language in our submission is essentially the same as Article 19 of the American Convention. What that demonstrates, in one sense, is that there is a consensus about the application of these principles. The general comment, my learned friend says, doesn't refer to crime, but what it does demonstrate in our submission is that this is fundamentally about the development of the children. It doesn't suggest that the provision does not apply to children, and the Inter-American Commission has applied that principle essentially about the importance of the development of children to, the Inter-American Court, I should say, has applied that principle to bring in considerations such as the best interest, and in our submission that must be right. If it's very difficult to see how a provision intended to protect the rights of children can be operated essentially without consideration being given to their best interest, given the importance of that. My learned friend says the general opinion, or the general comment rather, demonstrates how different policies can be adopted by different states. And again, that's correct, but there are clearly plain limits. I mean, if Article 19 of the American Convention, Article 24 of the UN Convention, of the ICCPR rather, Section 3.3k is to have any meaning, it is that it imposes limits. And that's, in one sense, where one goes to other expressions of the rights of the child to see what the limits on the treatment of children are. My learned friend says Section 13.3k does not incorporate the UN Convention on the Rights of the Child, but of course that's not our point. It seeks to protect the rights of the child, and the real question is When enacting that, was that language used in any way to restrict the rights that would otherwise be enjoyed by reason of international treaties? And in our submission, the answer is no. My learned friend pointed to Article 13.2, the right to qualify rights, and Article 13.1, the right to respect the rights of others. 3 points we'd make about that. The first is that although Article 13.2 appears on the face of it to permit the qualification of any right in Article 13.3, there must be limitations on that. For example, torture comes within Article 13.3. In our submission, and I've already made this point, the need to consider best interests is an absolute provision. And the reason for that is, as I've already indicated, it doesn't actually constrain the state or it doesn't prevent the state, for example, from imposing lengthy prison sentences. It simply means that a factor that applies to all children has to be considered. Secondly, and it links back to the point I've already made in one sense, if we're correct in saying that through Article 13.3k, one imports considerations of best interests, nothing that results from that prevents effectively the state protecting the rights of others. As I've already indicated, we accept deterrent sentences can be imposed. And thirdly, I make a point in any event about the absence of evidence regarding this specific point, which is about the best interests. Finally, my learned friend says in relation to the Charter, or not finally, but he makes the point in relation to the Charter that there are specific provisions dealing with the rights of children. Those specific provisions appear in, for example, section 14.1g, but the structure of the Charter is clear. Section 13.3 sets out a series of rights in very general terms, terms which are, given the approach in Boyce, intended to permit the courts to provide the detail. What then happens, or what is then sort of included in the Charter, section 14 onwards, is more specific detail in relation to some of the rights, but only in relation to some of the rights. So section 14, if I can remember rightly, is specifically concerned with detention. But that doesn't suggest in any way that there is an intention to restrict the rights set out in Article 13, Section 13. Some of those rights, as I say, are just not addressed later on, and clearly the material demonstrates what Section 13.3k is intended to do is increase the rights of children. Now, my learned friend went on to address the living instrument approach. We submit that Boyce is clear that my learned friend is wrong, essentially, to argue that the effect of constitutions cannot change. In our submission, what Boyce demonstrates is that general words are intended to allow development, and that reflects the fact that the standards of just societies change. We submit treaties are the best indication of what the standards of just society are. Now, in that context, my learned friend made reference to margin of appreciation. In our submission, one needs to be cautious about the language of margin of appreciation. Margin of appreciation in our submission is a principle that applies, but it's in certain circumstances, but it applies in particular circumstances. It's not some general get-out-of-jail-free card for the state. Matterdine makes the point that, as a matter of international law, there is no obligation on states generally to enact legislation that specifically incorporates treaty obligations. How a state complies with its treaty obligations is ultimately primarily a matter for it. But that doesn't mean it can ignore those treaty obligations. It has no margin as to whether it complies with those treaty obligations. It has to comply with those treaty obligations. Now, the dualist system, obviously, it is a matter of a principle of domestic law. It's not about marginal appreciation. It means essentially that quite clearly a state doesn't have to comply with its domestically with its international obligations. And the Constitution permits that. It permits that in Section 49, which allows essentially the Parliament to legislate in a manner that's incompatible with the Constitution. But that provision wasn't relied upon. I mean, had Jamaica wanted to say, we want to depart from the UN, from the obligations rather under Section 13(3)(k) in relation to children when minimum sentences are imposed, the procedure under Section 49 would have allowed that. But that wasn't the approach adopted. And in those circumstances, the normal interpretive rules apply. And when considering those interpretive rules, the question my Lord Steckland Morgan asked about Article 37 is of some significance. My Lord asked my learned friend, summarising, I hope, fairly, whether or not essentially Jamaica was seeking to comply with Article 37 or whether it had expressly disapplied that. The only real example given was the issue that arises in this case, the fact that there is a minimum sentence, which on the face of it appears to be inconsistent with Article 37b. Now, that then suggests that in general, Jamaica, far from wanting to disapply Article 37, recognises the importance of Article 37. And that goes back to the interpretation of the Charter. Is there any reason to believe the Charter doesn't, through Section 13(3)(k), incorporate international standards regarding children? In our submission, there is none. And ultimately, reliance on the minimum and the decision of Parliament ignores the primacy of the Charter. And my learned friend says, in any event, the 15 years is the shortest appropriate time because that is what Parliament has decided. But of course, Article 37C in our submission has to be read with the overriding principle at Article 3, which is the importance of considering the best interests of the child. And there's no evidence at all that Parliament considered that. I mean, Parliament couldn't have considered that because it didn't have the individuals before it. My learned friend then went on to make some submissions about the relevance of subsequent treaties. From our submission, in our submission, it's difficult to see what the relevance of that is, because the charters, when the Charter was enacted, as my learned friend says, I think, all relevant treaties had been ratified. So, in one sense, where does that take one? And my learned friend relied on Lendor, page 906, paragraph 59 to 60, to argue that differences in legal systems mean that legal systems develop effectively their own traditions. The problem with that argument, or the difficulty with applying that argument, is that the Charter, which is obviously now a provision that was enacted by Jamaica through its own processes, recognises that there are limits to those developments. And the difficulty for the court is to determine what those limits are. And that's where the approach of Boyce in our submission in particular is so important, because what it indicates in our submission is that the critical question ultimately is, what are the standards of a just society? Because that is ultimately what the Constitution is seeking to achieve, a just society. And that's where treaties are so important, because treaties give an indication of what a just society is. And my learned friend also relied on Lendor, para 61, in relation to what was said about the ECHR. That focuses, if one reads the whole of paragraph 61 in our submission, on the fact the ECHR was not binding on Trinidad. We have focused primarily on decisions of bodies regarding treaties that are binding on Jamaica. We've made reference also to the ECHR, in part because those bodies recognise that it's unlikely that the standards vary dramatically. But we started off, and in oral submission, I think all our submissions were based on decisions of bodies interpreting treaties that Jamaica has ratified. So that particular problem that arose in Lendor, which is why apply an instrument that is not applicable, not binding essentially on Trinidad, does not arise in this case. A learned friend then went on to relief and argued what should happen essentially if a violation was found. From the appellant's point of view, in one sense, how one approaches it, what relief is ordered, we would submit may not matter. If the court concludes that a Jamaican court can and should disapply the mandatory minimum, where application of the mandatory minimum would result in a sentence that breached the Constitution. The consequence of that is, in our submission, firstly, that judgment will obviously guide future courts and will provide relief for others, but more importantly, for the appellant, in our submission, if we're right about the way in which the Court of Appeal and the trial court approached this, the sentencing in this case wasn't constitutional, didn't take account of best interest, for example, didn't take account of the principle that the sentence needs to be the minimum shortest period. The case gets remitted, he presumably has to be resentenced in accordance with the correct principles, disapplying the legislation in his case. Alternatively, obviously if the legislation is declared unconstitutional, the same thing happened. There was a provision that shouldn't have been applied, that was applied. He needs to be resentenced, the matter needs to be remitted. What in our submission one can't have is the situation where the appellant was denied a constitutional sentencing provision, and either of those routes will result in him benefiting from a constitutional provision. What I would also, though, note is that in passing, if the reality is that we are correct, that in particular there is a need to take account of the best interests of the child, then the legislation will prevent that happening in a very large number of child cases. The only time it won't prevent that is where the child is facing an extremely long sentence that means that best interests can be taken into account and the minimum and the sentence in excess of the minimum still be imposed. In terms of, though, going a little bit, perhaps trying to give the court a little more assistance than saying it doesn't really matter, we would submit Section 13.2 is intended to apply retrospectively. I mean, that's why, for example, there is a savings clause, and it does limit the powers of Parliament. Section 2 undermines it doesn't undermine that argument. What it potentially does, in our submission, is essentially give the court what might be described as a blue pencil power, the power to either add or remove words. And obviously one way of doing this would be to say that the provision in question doesn't apply to children. And that, in our submission, would achieve compatibility, particularly if it is read then with a judgment which says, although it doesn't apply to children, it provides a guideline as to the correct approach. The Canadian authorities in our submission of limited importance, partly because they're applying a different approach. Having said that, we would ask the court, I'm not going to take you to it, to consider the more recent judgment of Lloyd, which is at page 1965 of the bundle, paragraph 22, which essentially sets out the current position, which is that a sentence in a piece of legislation in Canada is disproportionate, as we understand it, or unconstitutional rather, if it produces grossly disproportionate sentences. And that was applied in paragraph 37. My learned friend also relied on Morrissey as authority for the proposition that grossly disproportionate equals abhorrent. One of the problems with those sorts of labels in our submission, which it remains in one sense a difficulty whether or not one applies the abhorrent test, is how do you assess what is grossly disproportionate? In our submission, one of the ways one does that, it goes back in one sense to the point we've already made about the standards of a just society. One looks at what are the standards of a just society, and the standards of a just society in our submission are probably best demonstrated by international instruments. And those international instruments demonstrate the importance of taking account of the best interests of the child. So if you don't take account of the best interests of the child, you are not only imposing an excessive sentence in our submission, you are imposing one that is contrary to accepted standards for a just society, and that results in something that's grossly disproportionate in our submission. My Lords, I think that covers everything I need to cover. Do you mind if I just turn around and...
Of course.
That covers everything, my Lord.
Do we have any questions for you either?
Thank you. There's one sort of final housekeeping matter. I think I realised while I was on my feet that I thought I'd answered all the questions in my note. I think my Lord Second Morgan asked one about the Gun Court Act. I need to check with him because because I was on my feet before. I didn't take a note of that. I don't think we've answered that question. If we can send that in by way of an email, what the answer to that is, and if there's any other questions we've missed, then I'm quite happy to answer those. But I don't think there are.
Thank you, Mr. Sully.
Thank you.
Well, do you happen to know if the appellant is still in custody?
The information we've received suggests he is. I use that slightly soft language because the email we received was referred to checking with the institution where he was believed to be.
Yeah.
So I'm not 100% sure that's reliable, but the suggestion appeared to be in the email that he had probably 2 to 3 years to serve, I think, if I remember rightly. Yes.
Well, we'll bear that in mind in our timetabling of this. Well, we're very grateful to Council for their submissions. We'll take time to consider all that's been said and decide on the advice that we will humbly tender to His Majesty. We'll adjourn.